Hello, everybody. Thank you again for joining us today. I hope you're having a good Friday. As Joe said, today you're going to hear from myself and the two other attorneys who practice in this vaccine injury compensation program, Rhonda and Patrick. And the purpose of this webinar was to talk about some of the issues that come up, both current events, which is what I'm going to kind of touch on today. Then also, obviously the most common injury that we see and most of our clients have experienced is this SIRVA injury. So we're going to spend a decent amount of time talking about SIRVA cases and the lifespan of a petition and how those cases are prosecuted in the program. So thank you again for joining us. If you have any questions at any point during the presentation, feel free to use this, the chat feature on this Zoom program. We'll be able to monitor that as we're going along, and we'll try and answer as many of those questions as we can. So without further ado, I'm going to share my screen now, and I hope you bear with us with the technology as we try and do this. So here we go. All right, so hopefully everybody can see the screen now. What I'm going to do is go through and talk about some of the things that we've seen over the course of the last year in the program. So the first thing I want to touch on, which is what's something that we've all it's been in the news a lot, and I'm sure most of you, if not all of you, have received or been administered the COVID-19 vaccine. So the current status of COVID-19 vaccines and whether or not you can receive compensation for injuries due to those vaccines is that because back on March 17th of 2020, the Secretary of Health and Human Services declared a public health emergency under the PrEP Act, which effectively provided immunity from liability for any claims of injuries resulting from what they call countermeasures. And the COVID-19 vaccine is a countermeasure under this PrEP Act. So if you receive a COVID-19 vaccine or administered a COVID-19 vaccine and you are injured due to, let's say, negligence of the administrator or a medical provider, as long as that medical provider was a qualified medical personnel, there is absolute immunity from liability, with the only exception being willful conduct, if you can show that. So we already know that COVID-19 vaccines, as of right now, are not covered under the Vaccine Injury Compensation Program. They're not on the list of covered vaccines. So if you cannot sue the medical provider for, let's say, a negligence claim, and you can't bring a petition under the Vaccine Injury Compensation Program, what are your options? So as of right now, the PrEP Act allows for somebody who gets injured due to a COVID-19 vaccine, one of these countermeasures, to file a claim under the Countermeasures Injury Compensation Program. I'm going to refer to that as the CICP going forward, so we're not wasting any more time than we need to. What I like to refer to this program is a watered down version of the Vaccine Injury Compensation Program. And you'll see what I mean when I explain how it works. So if, let's say, you received a flu shot and you experience some kind of side effect or injury, you can bring that case under the Vaccine Injury Compensation Program. You have 3 years from the date of the onset of your injury to bring that claim. Under the CICP, the statute of limitations is 1 year from the date that you received the countermeasure. So many times we don't really understand or can connect an injury to a vaccine. And it takes some time to put those together. Doctors may not recognize it. You yourself may not recognize it. I know that I receive calls from folks all the time 2-3 years after their their injury, having just figured it out. So 1 year is barely enough time to get organized and put a claim together and file it with the CICP. So right there, I think that's a huge disadvantage for folks who are unfortunate enough to be injured by a countermeasure. Secondly, if we're in the VICP, you have compensation available to you that Rhonda and Pat are going to go into, but it includes past and future unreimbursed medical expenses, so any out-of-pocket expenses, which is also available under the CICP. You do have lost wages and income available to you under the CICP as well. However, you're limited to a cap of $50,000 per year of lost wages or income. There is a death benefit that's also available in the CICP. However, crucially, there is no damages for pain and suffering under the CICP. Under the VICP, there's obviously damages for pain and suffering. It makes up a large portion of the awards for people, especially SIRVA cases. So not having pain and suffering damages really neuters this program and limits the compensation that I believe that a petitioner would be entitled to if they were injured by a vaccine. So and lastly, obviously many of you here are our clients, our current clients, so we can file a petition for you under the VICP, and we keep track of our time, and we're able to then file our own petition for our fees and our costs. There is no such provision under the CICP. There is no attorney fee provision, and we would not get our costs back if we represented you in filing a petition in the CICP. So that, I think, is maybe the most inadequate part of this program. Not having any representation as you're trying to navigate this program, which is completely new to most people that have never even heard of this type of thing before, makes it almost impossible, I think, to get the compensation that you deserve. So, and then obviously the last, just the cherry on top is that if there is an adverse decision in the CICP, you do not have an option to appeal that decision. Whereas in the VICP, you would be able to file an appeal to the U.S. Court of Federal Claims, and from there could even file an appeal to the U.S. Appellate Court. So, like I said from the start, it's a watered down version of the VICP. It doesn't adequately, I think, protect people who are unfortunate enough to experience an injury or side effect due to a countermeasure. And for those reasons, we're pushing very hard for COVID-19 vaccines to eventually be part of the VICP. I think that's where they belong. We're obviously asking the entire country to get this vaccine. So I think there should be an adequate safety net in place for those who are unfortunate enough to be injured by it. So with that being said, how does a new vaccine like COVID-19 get added to the vaccine injury table? Well, in general, for any new vaccine, there are 3 steps that must occur. So first, the vaccine has to be recommended by the CDC for routine administration in children and pregnant women. If you're up on the news, you'll know that Pfizer has done various studies with children in ages 12 to 15. They've actually shown that the vaccine is pretty effective in that group. So already we're seeing clinical trials in children, and the CEO of Pfizer recently said that he hopes to try and vaccinate as many children as possible before the start of the next school year. So we're pretty much there on this step. I would expect that we're going to start vaccinating children here in the near future. Second thing that has to occur is Congress has to impose an excise tax on the new vaccine. So this is something that if you've read my book, you'll know that The way that this compensation program is funded is by an excise tax on every dose of a vaccine, covered vaccine, that's administered. So Congress is the entity that has to impose that tax, and that signals that this new vaccine is one that's going to be covered under the program. It's going to be part of the program that's going to fund the program. So once that occurs, the last thing that has to happen is for any revision to the vaccine injury table, the Secretary of Health and Human Services has to publish that new rule to the Federal Register. And this is something, if you followed along with the SIRVA saga that we've gone through over the last year, you'll know that that can take some time as well. So those are the three things that must happen. And once those three things do occur, the new vaccine will be added to the table and it'll be covered under the Vaccine Injury Compensation Program. So obviously the question then is, when will COVID-19 vaccines be added to the table? This is something I touched on already. This is why I think it's important that they are added to the table. And I would invite you all to read this journal from the New England Journal of Medicine, this article by Kathleen Van Tassel. And it goes through all the reasons why COVID-19 vaccines should be added to the table, and why, as of right now, their current status in the CICP, it's really an inequitable situation for the people who are asked to get the vaccine. So I'll make sure to share this with everybody, and I really encourage you to read it. But like I said, the biggest reason is we want as many people to get this vaccine as possible. The government is asking everybody to get vaccinated. What we need is a proper and adequate safety net for those people who get injured by the vaccine. And as of right now, if you ask me, and you ask a lot of us that practice in this field, that doesn't exist right now. And it won't exist until this vaccine is added to the actual Vaccine Injury Compensation Program. So as I touched on earlier, we're all familiar, or most of us are familiar with the table revision process, having seen it with SIRVA. I expect that at some point COVID-19 vaccines will be added to the table. I don't know when that is going to occur. I think it will happen sooner rather than later. And obviously, whenever those steps start taking place, we'll keep you updated. And if and when it does get added to the vaccine injury table, the question then becomes is, let's say I got injured by the COVID-19 vaccine already, and then the vaccine gets added to the table afterwards. Do I have any recourse? If you look at the text of the Vaccine Act, and I can share this with you as well. I'd invite you to read it. It really goes through why the program was started in the first place. The Act specifically provides that if a new vaccine is added to the table, there will be 8 years of retroactive coverage for that vaccine. So if you received it 8 years after or before the vaccine was added to the table, you'll have coverage as long as you can bring that claim within 2 years from the date of the revision to the table. So if tomorrow they revise the table to add COVID-19 vaccines, if you got it anytime 8 years before, you'd have 2 years from tomorrow to bring that claim in the Vaccine Injury Compensation Program. That's for any new vaccines that are added. And for instance, this happened when SIRVA and Guillain-Barré syndrome were added to the table as injuries. They provided for 8 years of retroactive coverage if you were injured by, let's say, a flu shot and developed Guillain-Barré syndrome. They allowed any claims for anybody that was injured 8 years prior to the revision to file a claim. This is a little different only because this is a countermeasure. It's anybody who receives the COVID-19 vaccine right now is doing so under a public health emergency declaration. And there's a question of whether you can still pursue a claim under the VICP even after the public health emergency declaration is lifted. Certainly you would be precluded from pursuing a negligence claim because the public health emergency declaration and the PrEP Act provide immunity for all those injuries. So it remains to be seen if this Vaccine Act, if it will provide for 8 years of retroactive coverage. It's something that we're pushing for, and we're hopeful that there'll be some kind of look back provision when it is added to the table. Even if there is no retroactive coverage for COVID-19 vaccines, it does look like that if you were up on the news yesterday, that COVID-19 vaccines are here to stay for a while. The CEO of Pfizer came out yesterday and said that it's likely that in the next 12 months, we might need to get another vaccine. And that kind of points to a situation where COVID-19 vaccines may become seasonal. It may be like a flu shot where we have to get it every single year. Obviously, there's a lot of speculation. We're not sure what may happen in the future, but if and when the COVID-19 vaccines are added to the table and we have to continue to get them, we're still hopeful that at some point they do get added. So if we do have to keep getting these vaccines in the future, any future injuries will be covered. So the other topic I wanted to touch on is the SIRVA rule change, because as of right now, it's still pending. A lot has happened over the last year. And if you've been following along with some of our blog posts and things like that, you'll know that it's been quite a saga. But this is a little bit of a reminder of the history of this rule change. In July of last year is when the Secretary of Health and Human Services initially proposed the rule to remove SIRVA from the table. And when I say remove it from the table, what I mean is the vaccine injury table, obviously provides lists of covered vaccines, but they also indicate the injuries that are associated with those vaccines. If you're able to meet the criteria of the table, and this is something that Rhonda and Pat are going to go through, there's a presumption that the vaccine caused your injury. So it's crucial to a lot of the claims that are made in the vaccine injury compensation program. Removing SIRVA from the table wouldn't necessarily preclude you from filing a case alleging a SIRVA injury in the vaccine injury compensation program, but you would have to prove that the vaccine actually did cause your injury, and you wouldn't be afforded that presumption any longer. So it's something that we obviously, as a bar association and us ourselves, fought to prevent this rule change from going into effect. We did so up until January 21st, when the rule change was published in the Federal Register. They gave it an effective date of February 22nd. And we thought maybe with the new administration, something might happen. And it did. When Biden was inaugurated and the new administration came in, they put a pause on this rule change from going into effect. So that happened on February 19th, and it has been delayed until April 26th or 23rd, a week from today, actually. Back on March 17th, about a month ago, the new administration actually proposed to rescind the rule entirely from going into effect. So no more delay, just take the rule out from being effective whatsoever. So that is still open for public comment actually today. It will close today. So if you haven't already, I would invite you to visit the Federal Register. Here's the link here. And you can submit a formal comment in support of their decision to rescind the rule to remove SIRVA from the table. Already we have 94 comments. We'd like to see that number get up even higher, really show them that this is something that we're all in favor of. So we expect that at some point next week, that rule will go into effect, and the table will remain as it is today. There will be no removal of SIRVA. So now I kind of want to talk about a blend of my two topics here before I hand it off to Patrick. But we've been getting a lot of calls from people who unfortunately have experienced a SIRVA injury due to a COVID-19 vaccine. And as I talked about before, without any attorney fee provision in the CICP, we're really without, we really can't offer them much at this point. And until COVID-19 vaccines are added to the table, we'll continue to point them in the right direction and tell them about the CICP and their options for filing a claim. But until that happens, there's not much else we can do. So the table right now has a section. Here, let me pull up the table for you real quick. If nobody has seen this before, this is what the vaccine injury table looks like. It's actually a table. There's 3 columns. As I said, there's the covered vaccines, the list of injuries or illnesses associated with those vaccines. But in particular, I want to show you this section, which was very important to us during this whole SIRVA saga. And this is the last section here. And what this section says is that for any new vaccine that is recommended by the CDC for routine administration in children and pregnant women, that once the vaccine is added to the table, SIRVA and the fainting injury will automatically be associated with that vaccine. So this is, this was very important to us during the SIRVA removal thing, because if SIRVA was removed from the table, these 2 injuries were both proposed to be removed. So this whole section would have gone away. And if COVID-19, let's say, was added to the table, there would be no SIRVA injury associated with COVID-19 vaccines. Now that this section is going to be remaining on the table, if and when COVID-19 vaccines get added to the table, SIRVA will automatically be associated with it. So we can just go ahead and file those petitions alleging SIRVA and have it meet the criteria of the table and be afforded that presumption, rather than waiting for HHS to propose to add SIRVA as an injury for COVID-19 vaccines and go through that whole process. Will automatically give us coverage.